first time you have about 10 petitions being sent for the removal of the EC commissioner. It's the first time. I mean, so it's huge. So it means that there's a general perception of people that the electoral commissioner and her deputies engage in some form of misbehavior, stated misbehavior or incompetence, and so they wanted them out. And it's a right vested in any Ghanaian. So when the people sent and I agree, I'm shocked at the decision, because when you look at that, the decision of Justice Bafo against earlier decisions, you find it difficult to rationalize his decision. And let's give you one example. The Constitution again gives the EC the power to create constituencies. But in the creation of the constituencies, there are certain procedures to be followed. The constituency must be created before the next election. Because if the constituency is created now, the people they cannot be represented. If not, the government could create more constituencies in the MPP areas to further decimate MPP, if we allow that. So the whole rationale is to lock it in and make it impossible to determine the outcome of an election when a sitting parliament is there, and also not to change the composition of that parliament. So in 2020, EC created constituencies. Created who? Hohoi. Okay, and in the creation of Hohoi, it left 4 communities. 4 communities. Sal, Apafo, Lulubi, and Likwe. Left them. Now, I was in Parliament. The EC electoral commissioner came to Parliament. The late MP of Hohoi drew the attention of the EC commissioner in Parliament that the description of the Hohoi constituency seemed to exclude 4 communities. And if that was not rectified, the 4 communities would not be represented in Parliament. So it was not something that was not brought to her attention. It was brought to her attention. Now, somehow, for 4 good years, the people of Santrofi and Apafo, Lolobi and Likwe were not represented in Parliament. Look at what the Chief Justice says. Oh, you don't want me to read the Chief Justice's report? It says, while the allegations raise serious constitutional and administrative questions, they do not on their face meet the threshold required for a prima facie determination of stated misbehavior or incompetence, warranting that a committee be set up to inquire into the petition. So Chief Justice says that, well, such constitutional breaches or administrative breaches are so serious. Okay? But that on the face of it. So that's where I disagree. Do you need intentionality? Do you need to prove intentions when you are breaching the Constitution? You need to prove the fact that a constitutional provision that has been breached. I mean, you can't use intention to obviate the requirement of the law to question the competence of that person, because it's a constitution. The constitution says you must do it this way. Then the Chief Justice says, no, it's not that weighty. But for now, we now know that there are some constitutional provisions, the breach of which are not weighty to require inquiry. So this is a problem. This is a problem, and it has thrown almost all constitutional lawyers, and lawyers in particular, into confusion. Because you look at Charlotte Otey, it was not a constitutional breach. It's an alleged procurement law breach, statutory breach. That was weighty enough to require the setting up of an investigative body for her removal. And we can argue that we can now argue that probably Tokuno was subjected to a weaker standard. Okay, so that is an inconsistency in judicial pronouncements and pronouncements of this nature, and has thrown the whole Article 146 again into debate. So he says threshold. So what is the threshold? Who defines the threshold? Where can we find evidence of that threshold to inform ourselves and guide our future petitions? So these are the matters that his ruling is evoking.